Yes, hello my beautiful friends and welcome back after a full reset of all the tubes over here. We're very glad to have you. Happy Friday. I hope your week was just outstanding. We have a tremendous live stream planned ahead. We got a bunch of segments to get to today. Letitia James laid bare, exposed 11 exhibits submitted into her prosecution case. Of course, we see here we've got Lindsay Halligan responding, Letitia trying to get her case thrown out, and the DOJ now firing back. So we're going to go into this. I got all the documents queued up. You can see various exhibits 1 through 11 here, all coming screeching in to the Letitia case. So we'll come back. We'll look at all of them. Got them queued up here. And she said that she was just picked out of the blue, weaponized prosecution, all the things. But the documents are now here. So we'll peer inside. Then we'll turn our attention to this story. Jim Jordan now saying that he got spied on by Jack Smith. Not good. Jack Smith already spied on a bunch of other people, including senators. But Jim Jordan's might be the worst because they went after his records for years. And we got Jim Jordan who was talking about this, and an article from Fox News, they got the exclusive on it. But Jim Jordan was talking about it with Hannity, saying this is a big problem. And Lindsey Graham says, we've got to sue Jack Smith and stop this from happening. And we hope that they take action on it. So we'll go into that. Then we got a Charlie Kirk update. I got a bunch of documents pulled up here. You can see we've been talking about this battle. The docket is filling up. You can see this is directly from the Utah court docket in the Provo district. And we got a bunch of stuff that we're going to get into. So you can see down here at the bottom, a bunch of stuff came skidding in yesterday. And this is about the media and access, whether the media can get properly noticed about closure hearings, because they're really trying to lock this whole thing down. And we also saw this story yesterday that there was some evidence was missing, which is not good. And there were some jail footage that some local reporters went to go get their hands on, and they don't have it. So some jail footage now gone. And so we'll get back into that. I've got a bunch of documents here in the Kirk Tyler Robinson case queued up here. You can see back and forth between the prosecution that wants Tyler Robinson locked away for a long time, maybe even under the death penalty. But we've got a back and forth. We've got the media wants to be a part of this, saying if you're going to close this stuff down and have little secret hearings like we saw they had before, we want to be apprised of it. And now there's a back and forth. The defense is objecting, Tyler Robinson's people, saying we want this. We don't want the media in here as official interveners, and they don't actually need proper notice of anything. So we've got the latest, several documents queued up here. We'll explain exactly what's going on, and we're making sure our red pen is properly queued up so that when we're back here, we got it ready to go. Then we'll talk about Kash Patel. He's now being sued by a fired gay FBI agent who said he's very upset that he couldn't fly his gay pride flag all over the place at the FBI. And so he's sued. Kash Patel now getting hit with the lawsuit. You can see Cash App and Pam and the FBI for not being very tolerant out there. So we'll go into it. We'll see what the latest is and see and check in on our FBI. Here's a little clip of this fella. So we'll listen to him for a bit. And then, of course, we'll see what you have to say about all of it. So we got a bunch of good stuff to get into, and we're excited about that. But before we do, you know what's coming up: Thanksgiving and Christmas. And of course, what do we do on Thanksgiving and Christmas? Well, we cook our little cabooses off. And one nice tool to help you do that, Chef IQ, baby. And we've talked about this. I actually love this device. It's perfect because what happens is you take these little ceramic prongs out and you just shove them right into the meats. This is ceramic, not plastic. And you just poke it right into the meat, and then you just let it do its thing. It's got an awesome app. You go into the app, download the app. It'll say, what do you want to cook? I'm cooking filet. I'm cooking some chicken breast. I'm cooking whatever. Poke that puppy in there, and it'll guide you through the rest of it. It literally will bark at you in a nice way. It's very polite. It says, it's time to flip your food. And I say, yes, ma'am. I'll go out there and just flip that food. No problem. So whether it's turkey or whatever it is you're cooking over this holiday break. It's a great gift too. I got one for a lot of the men in my life, my dad and my now father-in-law. Both got those for Father's Day, and I love it. I use it all the time. So check it out. You can go over to chefiq.com and grab yours. And if you use the code Robert, you're going to save 30% off. So make sure you do that. Code Robert, 30% off site-wide, Chef IQ, and it's really cool. So it's got all, cook whatever you want, and it'll tell you when to flip it, when to pull it off, when to tent it with foil, and all the things. So check it out, Chef IQ, QR code right there on your screen, links in the description, and thanks for supporting our sponsors. And don't overcook your meat. Get a Chef IQ. It's real. The app is great. It's really good. It charges well. It's really a nicely designed device. And your boy's picky about those things. All right, so let's get into it. On the day, I think the tubes are working now. Perfect. Finally, after an hour. All right, so we're here. Let's get to it because we got some business to attend to. Letitia James exposed. She said that she was being targeted, singled out, attacked by the weaponized DOJ, which is hilarious, coming from spasm-faced TISH, who has TDS to such a high level that her face spasms. But she, of course, wanted to dismiss her prosecution. Lindsay Halligan brought charges against her for mortgage fraud, and she says, there's no evidence of this at all. And then Halligan responded to Letitia's motion to dismiss her entire indictment, saying that Lindsay Halligan was being vindictive and selective. Lindsay responded, just like we saw in the James Comey prosecution, with a big tranche of documents. You can see them all here. 11 exhibits attached. We'll go through them. Applications, affidavits, insurance policies, credit card receipts, utility bills, everything. TISH exposed clearly, financially, which is good for us. So we'll go through all of those, but this comes on the back of this filing. You can see the United States of America, Lindsay Halligan, the Trump DOJ, responding to Letitia's motion and her attempt to dismiss the indictment. She says Lindsay is vindictive. She's nasty. She's coming after me. And she's just singling me out. This is a selective prosecution. Lindsay says, get out of here, Tish. We got evidence. It's clear as day. Here's where it starts. She says, all right, look. Judge, Letitia made material representations in her home loan application and a sworn affidavit about the type of home she was buying. Her actions show that she knew what she was doing, and she financially gained by getting a better mortgage rate. Remember, 3% rather than 3.815%. So if you dismiss this indictment solely on evidence that there are public disputes between Letitia and Trump, between senior officials from different political parties, there's no basis in the law to do that. Just because Letitia and Trump are sniping at each other and have been for years doesn't mean that's a basis to dismiss her criminal charges. Would you apply that to anything? If she got charged with anything, you could come and make that argument. Well, Trump hates me, so therefore my meth lab charges should be dismissed. No basis in the law, and if you allow this to happen, there will be extraordinary ramifications. Now, and as often has been said, they're quoting, that a prosecutor dislikes someone does not prevent a prosecution. Yeah. Prosecutors dislike most people. That's why they're prosecutors. It's a perfect job for them. And news reports on which Letitia bases her motions are not inappropriate justifications from casting aside the findings of a grand jury. Letitia was properly indicted, and she's just going to come and say, since Trump doesn't like her, all criminal charges get dismissed. She's got like Trump animosity immunity. She's going to make that up. They write, Judge, no evidence, let alone compelling evidence, demonstrates that Halligan herself exhibited any animus at all. Rather, according to Letitia, Halligan was tasked with assessing whether Tish could be charged. She even said, from Trump, President Trump said this, if they are guilty or if they should be charged, they should be charged. Don't charge anybody who doesn't deserve it. We're not prosecuting the innocent here. We're not the Democratic Party going after January 6ers who were invited into the Capitol. Insufficient direct evidence requires circumstances demonstrating vindictiveness. If you're going to say Lindsay's mean, you got to prove it through indirect evidence, creating a rebuttable presumption. Now, however, defendant TISH seemingly abandons this argument. And as the Fourth Circuit has held time and time again, a presumption of vindictiveness will rarely, if ever, be applied to a prosecutor's pretrial decisions. So we're not just going to start this game by saying that prosecutors are bad people. They'll just say, you have to go prove that. There's not going to be a presumption. Just like we have a presumption of innocence, you start the game at innocent. You don't start the game at maybe you're innocent or maybe you're guilty. That's a misinterpretation. You start it at innocent. Then they have to overcome that presumption beyond a reasonable doubt. Now, as its core, this case represents no more than a garden variety mortgage fraud prosecution. It's not vindictive. You're not special, Tish. You're just a typical mortgage fraudster. Now, the court is well familiar with the Eastern District of Virginia. And you know, Judge, it doesn't have anything to do with Tish. We prioritize fraud cases here in this district, regardless of loss amounts. And we go after mortgage fraud here. You know this. In fact, here was another prosecution. We just had this one, the Tayal case. That person fraudulently paid a mortgage at a lower rate. We just prosecuted that person. They made misrepresentations and other affidavits, and so they got brought forward. And then in Exhibit 1, look at all these other ones. These are low-dollar mortgage fraud cases that have all been brought in the NOR-F-Word division in the Eastern District of Virginia. Look at all these. Here, she says right here. They're all right here. Turner got popped. Talens got popped. Smith, Ackle, Hawkins, Strickland, Preston, Ward, Jomny, all these people. How come Tish wouldn't get the same standard prosecution as these people? Is she above the law? She lectured us for years that no one's above the law. Go on her X account and search for above the law on Tish's account. It's ridiculous. All these people. These are low amounts, $20,000, $47,000, $730 for restitution, obstruction by mail. That's a big one, $247,000, $31,000, $18,000, $505,000, $505, $18,000. That's about what Tish's was. So she's right in alignment. She's not being singled out. Look at all these other people. She's one of many, just a typical fraudster. And of course, there are all allegations out there. But that's Exhibit 1, saying it's not vindictive. It's not selective. Look at all these other people. The high-profile comparators that Letitia offers are outside of your jurisdiction, or the other cases that she generated and is comparing us against to say, look at me. One of these things is not like the other. One of these things is Letitia James. And she is being selectively attacked. They're saying she's picking cases that don't even match her case. They're not even in this court. And those people are actually innocent. Senator Roger Wicker is the only one of the purported comparators in the Eastern District in this district, and Letitia fails to inform the court that the New York Times reported that Wicker actually committed no fraud at all. This omission that she didn't tell you about, Judge, exemplifies the danger of relying on selective news sources to dismiss the indictments. The facts are untested by various federal rules of procedure and evidence, and they are now contradicted. The basis that she is using to dismiss criminal conduct that's not even accurate. So the remarks of presidents and state attorneys general are important. These, Letitia screaming about Trump coming back at her, but they do not have any bearing on the evidence on which the United States, the prosecution, and the grand jury, the people, have relied on in proceeding with an indictment. They weren't presented these people's tweets back and forth. Federal courts must not allow people like Letitia to escape a facially valid indictment supported by evidence because of public disputes between elected officials. If you do this, that would infringe on the prosecution of individuals for whom probable cause of the commission of a crime exists and effectively immunizes any defendant here about whom an official negatively comments. That's right. It's political animosity privilege. It's the PAP. The United States of America, and through its attorneys, Lindsay Halligan and others, oppose Letitia's attempt to dismiss this case. We're going to explain more why here now. Now, as we know, on October 9th, a grand jury returned a 2-count indictment against Letitia. 2 counts, bank fraud, and false statements to an institution. Now she's dismissing. She's saying Halligan is vindictive. She's attacking me. She hates me. She doesn't like me. She thinks I'm a bad person. It's attacking me unfairly. And Selective, that she's being singled out as opposed to other people. Now, the facts of this case are straightforward, Judge. and have clearly established probable cause of the commission of federal financial crimes. Letitia, she signed and submitted several home loan application documents with false information. Other official filings show that Letitia knew it, and she financially gained from all of it. Now, first, Letitia completed a uniform residential loan application. That was back in July 2020. She said, I'm going to buy a secondary residence to reside in. It's called a Perone residence. That's in Exhibit 2. Right here, Exhibit 2 from the government. The loan exhibit right here attached. They say it's right here, Tish. This isn't selective. It's in writing. Here it is. Oh, look at that nice loan rate. 3%. Isn't that convenient? And who is this for? Oh, yeah. Letitia right there. Letitia A. James, the biggest Tish in all of New York. And so a lot of this is redacted. They show the document. Oh, yeah. 728 right there highlighted for us. Look at that document. Probably redacted her signature and some other things. Redacted. But there it is. Plain as day. Tish. She completed an application. Now, the residence was not actually a residence, okay? It was actually an investment property. Them and their labels, which is important because falsely labeling a residence as a secondary residence mortgage allowed her to get a better interest rate. Now, second, this was no mistake. She's the New York Attorney General. She again made the same representation in another form she completed for the same property in August 2020. Exhibit 3, she did it again. Oh, look at that right there. Look at that little checkbox, Tish. One is right here. It's right next to the other. Primary residence, you're going to live there as your primary residence. Secondary residence is going to be a secondary home. And if you're going to make it an investment property, it's not complicated. It's the next box over. You have to check that box, Tish. And you didn't. Busted. That's just Exhibit 3. We're just warming up. So she continues. And third, Letitia represented that she intended to use the Perone residence as a second home, which she didn't, when she completed and signed under oath an affidavit of occupancy of the Perone residence on August 17th in Exhibit 4. Dun, dun, dun. Once again, signs it again. Affidavit of occupancy. Look at that checkbox. That's an illegal checkbox, Letitia. You're the New York Attorney General. You got Wall Street in your backyard. You're supposed to be a financial fraud guru and go prosecute the biggest corrupt fat cats that exist there. And you can't even sign a form correctly here. Is it your primary residence? No, she knew that wasn't going to work. Why? Because she lives in New York. She's the New York Attorney General, not in Virginia. So she said second home. Oh, what's this box right below it? Investment property, not owner occupied because it's going to be occupied by her nieces or whatever, purchased as an investment to be held or rented. Oh, Tish. Tishy lay Tish. Another one. So it's weird. She keeps making the same mistake over and over and over again. How strange. We go back. Now, in that sworn affidavit, and let's see what else we have here. Signed by Letitia James. Exhibit 4, right there. Evidence. Busted. The agreements here are contained in herein shall survive the closing. And look at this. Whoever, Tish. Whoever knowingly makes any false statement or report for the purpose of influencing the type of loan that you're going to get might be imprisoned for 30 years and fined $1 million. She said, I'm Letitia James. I'm prosecuting Trump right now. Signs the document. And then goes and attacks her political opponents for fraud that they did not commit. So Letitia says in that sworn affidavit, she attested that she would occupy the property as a second home, like a vacation home, while maintaining the principal residence elsewhere. She also acknowledged, again, under oath, that the affidavit of occupancy is given as a material inducement to cause the mortgage company to make a mortgage loan, a cheaper rate mortgage loan. And fourth, Letitia also signed a document called a second home rider. We're now on Exhibit 5. How many strikes does it take to get to the center of a mortgage fraudster? August 17, 2020, this amended the mortgage. It's in Exhibit 5. Letitia said over here in another exhibit right here, second home rider. Wow, that's curious. August 17th, this is incorporated, shall be deemed to amend and to supplement the original mortgage, signed here by Letitia James. And what is she signing here in Exhibit 5, as you can see? Oh, here's what it says. Occupancy. She signed it. All right, so I'm Letitia. I'm a smart New York Attorney General. I'm the Chief Law Enforcement Officer of the entire state of New York. A borrower, in this case Letitia, will occupy and use the property as borrower's second home. And borrower will maintain exclusive control over the occupancy of the property, including short-term rentals, and will not subject the property to any time sharing or other shared ownership arrangement, or to any rental pool or agreement that requires the borrower either to rent the property or give a management firm or any other person or entity any control over the occupancy or the use of the property. Borrower will keep the property available primarily as a residence for the borrower's personal use, for her use and enjoyment for at least 1 year after the date of this, unless the lender otherwise agrees in writing, which consent shall not be unreasonably withheld, or unless extenuating circumstances exist beyond the borrower's control. I'm sure we'll see her try to use that. But here also, you're in default if you give us materially false or misleading or inaccurate statements, or if you fail to provide us with material information about your occupancy as a second home, then you're in breach of this agreement signed by Letitia James. Halligan continues. Wow, a second home rider. It's going to be a second home, right? Now, finally, in connection with the Virginia Perone residence, Letitia submitted 2 insurance applications as well, August 25th, October 17th. In the first application, she said that occupancy, owner, residence, usage, non-seasonal. She took the action of marking several months in which the Perone residence would be unoccupied. That's in Exhibit 6. Now, under these representations in Exhibit 7, she acknowledged, I have read and acknowledged reviewing and understanding the contents of this page, which, is a pretty tall order for Letitia to understand much of anything. But here is Exhibit 6. She gets the mortgage. I got to go get insurance for it. She goes to Universal Property, an insurance company. She says, I'm Letitia James, and my agent is this person helping me. This is an insurance application. First mortgage is through these people with the loan number over there. Payment submitted over here. Billing information, mortgagee. And isn't this curious? Exhibit 6, occupancy. Who's going to be living in it? The owner. Residence usage, non-seasonal. So she's going to be there a lot. Months unoccupied, February. So interesting. So her schedule, according to the insurance people, was every other month, basically. Which is curious. Shouldn't she spend more time with the people of New York? Why is she leaving her constituency to race off to Virginia every other month? Does she hate New York? She wrecks it. She's like, I can't live in this hellhole. It's a disaster. Well, you made it that way. I can't live here. I got to get out of here. So is that the thesis? No, it was really a rental property. So other information here all goes in the insurance application. Yeah, I need this and I need this and I'm going to have this insured. Exhibit 7 adds more. And lots of redactions here, but they highlight this for us. They say occupant. Oh, Letitia James, adult occupants. Here, who's going to be living there? Letitia, not her degenerate family. Children in household, none. Total number of residents in the household, including children, 1 person. She's going to live there forever alone. The date the applicant moved into the property, 10, 20, 20. Number of dogs on the premises, they say none, but it's arguably one. Are either applicants eligible for the Good Hands program? No. And this all becomes effective. Signed by Letitia James once again. Busted in Exhibit 7. Second home. I'm going to be the sole occupant. Don't have any dogs. I'm going to live alone probably for the rest of my life. And can I have insurance, please? Halligan continues. She says, in the second application, she represented adult occupants. One occupant, Letitia, alone, forever. Above her signature, she again acknowledged that she read the entire application, including the binder provision before signing the document. So she knew what she was doing. Now, Letitia's actions show that she knew the Perrone residence was not a secondary residence. It was an investment property. In fact, she stayed in hotels when she went to Norfolk, Virginia, despite representing that the Perrone residence was her secondary residence. If that was her home, why didn't she go stay over there? This is because her home wasn't a secondary home at all. In fact, she purchased the residence for a relative from whom she collected rent while enjoying the financial benefits of the lower mortgage rates. Schedule E is detailed in Exhibit 9. Supplemental income. Oh, Letitia James right here. Supplemental income, reporting it on her taxes. Schedule E, 1040. Sends this one. Oh, it's the Perrone Avenue in Virginia, right there. Fair rental days. 146 rental days. 0 of use. Rents received. She got $13.50. And that's, pretty light rent. Rents received $13.50 for like 146 days of rent. This is interesting. Total expenses. Oh, so she can deduct from her taxes because she's got to pay out for her income for her rental property. She's got to pay out for the rental property, not get income from the rental property, rather. Oh, Letitia, you're trying to even cheat on your taxes? Is that what's going on here? Halligan continues. She says, in September, and let's back up. Did we look at Exhibit 8 yet? I think we may have skipped over that. So this was Exhibit 7 that showed that. Let's go to Exhibit 8 over here. Statement period, Citibank. What do they have here? Statement period, August 5th to September 7th. Oh, there's Letitia. Look at her staying at the Renaissance Hotel in Portsmouth, Virginia. Wow. I wonder how much it was for. Wonder if she got the massage or if she watched any movies. The Renaissance Portsmouth Hotel. 2 charges. Oh, a couple days. $825. So one of this was probably for the room. And then one of this was maybe for a facial or something. And then we had another one on $827. Well, she just kept staying there. 9/1. This was a long trip. Yeah, why wouldn't she go to her house and stay there? Another hotel at the Renaissance. Interesting. What's she doing over there? And man, how would you like to be this person redacting every single every single character one at a time? Like just redact this whole thing. It's nice of them to show us exactly what they're covering. We appreciate it. But okay, so busted, man. And they got some documents, some checking account documents, and she busted. Why wasn't she staying at her second home if it was a second home? Because it wasn't a second home. So in September, a relative registered utilities in her own name as well. So her niece came out, and in addition to Letitia claiming a loss on her rental properties that are not supposed to be a rental property, we also got the property utilities for the Perrone Avenue residence being taken out in not Letitia's name. The bill cycle is for something over here, and I think they may have redacted her name actually. So the main customer is right here. I don't think they're putting her name in it. So the setup date was in 2020. Bill cycle something monthly. So the person who's actually on the utilities, her family, I think they redacted for us. So the account ID and the main customer. So it's, probably the niece, but they're not going to show us her name because she's not charged here. Customer, but move-in date 9/1, Exhibit 10, the Perone Avenue, Dominion Energy in Virginia, not in TISH's name. Furthermore, in October, a relative attempted to use the Perone address to register to vote. Now, in official filings, Letitia at least twice stated that the Perone residence was actually an investment property, but never took steps to amend the material falsehoods on her mortgage documents. She represented that the Perone residence was an investment property in her income taxes, including taking deductions consistent with an investment property, not a secondary residence. Now, these deductions demonstrate that Letitia never occupied nor intended to occupy the Perone residence as the mortgage terms required. In fact, defendant Letitia continued taking the investment property deductions for several years until in 2024, she told her accountant, "Get out of here." They've got a text message from Letitia. Oh, Letitia told her accountant, "I do not want to take deduction. It looks suspicious, and I need to do everything according to the tax code." Wow. She took it for several years until she knew she was going to be in trouble. Holy crap, Trump's going to win. It does look suspicious because it is suspicious, because it's illegal. The evidence demonstrating her knowledge does not stop there. So they went to her accountant, somebody, and they got a text. It says here, defendant listed the Perone residence as an investment property, not a secondary residence, in the New York State financial disclosure form for public officials. So she was getting it on both ends. Now, even though it instructs officials not to list any real property, which is the primary or secondary personal residence of the individual, she listed it there as an investment property, which is the opposite of her mortgage. So this was neither a benign mistake or an innocent mix-up. Letitia's actions show she knew it was an investment property because she didn't want to report the other properties. It resulted in a mortgage rate of nearly a percentage point less. So she was reporting it as it was, but lied on the mortgage so that she could get a lower rate, save some money, and then put her family in there, let the property increase in value over time, and then cash out after her political career is up or whatever. So they say, all right, she's busted. We got all these exhibits. It's pretty clear what went down over here. And Exhibit 11 is her financial disclosure statement that shows that it's the opposite. Says list certain properties. Do not list any real property which is a secondary residence. Okay, if it's secondary, which she said it was in her mortgage documents, don't put it on this form. She's like, well, it's not secondary. It's an investment property, even though I told the mortgage company it was secondary. So then she puts it on here right there, Norfolk, Virginia, single family, and she owns 100% of it. So we've got all 11 exhibits laid bare. Letitia, as you can see in the materials, she did it. The Attorney General and the U.S. attorneys, we have broad discretion to enforce the law. That means so long as a prosecutor has probable cause to believe there was a crime, then we can bring a charge. And we are entitled to a presumption of regularity. She's screeching at us that this is vindictive. You have no evidence. You're just targeting me because you hate me. It's in writing, Judge. Look at the 11 exhibits. There's plenty of cause. That's why we're here. Nevertheless, a prosecutor's discretion is of course, subject to constitutional constraints. We have the Due Process Clause and other constitutional protections. And so we want to make sure those are not being run roughshod over. But courts remain hesitant to review a decision to prosecute a defendant. Okay, we have this thing called judicial deference. The judge is not the prosecutor. The prosecutor is the prosecutor. And so the judge defers to them. Unless you have sufficient direct evidence, it is nearly impossible to dismiss a claim for vindictive prosecution like TISH is trying to do here. You need to have a lot of evidence. Claims must be supported by a sufficiently strong showing of evidence to overcome the presumption for the prosecution that we're acting with regularity. It's a rigorous standard, and it's a high one. Now, for a vindictive prosecution claim, the defense in this case, Letitia, she would have to show through objective evidence that the prosecutor, that Halligan, acted with genuine animus towards the defendant, and that she would not have been prosecuted but for that animus. In other words, Lindsay Halligan hates Letitia, and if Lindsay Halligan didn't hate Letitia, then she wouldn't prosecute her. And you can see they're putting prosecutor in italics here to say it's the prosecutor, not the president. The first prong requires them to prove a vindictive motive to say that Lindsay hates Letitia. And the second prong requires evidence that this is only being brought for the sole reason to punish the defendant. In other words, there is no justice to be had. You just hate this defendant. Now, this motion fails because there is no evidence that Letitia is providing at all, let alone any clear evidence that there is vindictive animus, and there's no basis to dismiss any of this at all. They continue. Lots of case law and rules. You can see all of these italics here, emphasizing the cases that they're going to explain what the rules are, but we'll understand the rules when we do the application right now. The defendant, Letitia, there is no direct evidence that she needs to present to show that Halligan exhibited animus. Why? Because she has none. There is no evidence. She said that Halligan's silence is immaterial. In other words, Trump is screaming, but Lindsay is silent. And she's not refusing to condemn Trump. They say, well, so what? She doesn't have to say anything. And instead, they bring in these news reports to say, well, Lindsay's vindictive because the news is reporting. They say that's not enough evidence. Rumor, innuendo, gossip, you can't use that in a vindictive claim. And moreover, prosecutors may differ as to whether probable cause exists, and so prosecutors have some discretion. One prosecutor's initial decision does not freeze future conduct. That first prosecutor who's like, I can't find any evidence of a crime here. Maybe they're just idiots or partisan hacks and dishonest people. Pick one. Probably all of them. But defendant here, Letitia, has not presented direct evidence of any animus from Halligan at all. Now, she also fails because of other reasons. Well aware that no direct evidence shows that there is any animus, she then tries to impute that animus. She says, well, it's probably coming from the president. Lots of case law here about, can you do that? But even if the court says that Lindsay Halligan is like a stalking horse for the president, Trump's own briefing or TISH's own briefing establishes the concept's inapplicability to this case, even if you want to use that claim. When courts entertain the imputed animus theory, like a prosecutor's acting for somebody else, there must be evidence the prosecutor didn't make the ultimate decision to bring the case. There's no evidence here. For the stalking horse theory to apply, Letitia must connect the animus the non-charging official harbors to the prosecutor, in this case, Trump to Lindsay, by showing that Trump in some way pressured her to make the decision to seek the indictment. Now, evidence that an investigation existed before the charge doesn't support anything. In another case, South Carolina, this case called Wilson, a U.S. attorney sent an email to a North Carolina attorney explicitly requesting the indictment of a particular defendant. But the Fourth Circuit didn't even impute any alleged animus there. And they cite this other case, but again, this case is 30 years old. It's not even in this circuit. And so it shouldn't be applicable here. Now, she also argues, Letitia, that an improper purpose for an indictment exists when the government has followed unusual discretionary procedures. But those claims aren't applicable here. She has not presented sufficient evidence that Halligan did not make the ultimate decision to charge her. She hasn't presented any evidence of Halligan's animus. And so this should be the end of it. The court's decision should be over. If they don't present evidence, then we have a presumption of regularity and her claim should fail. Now, finally, even if you do say that there is imputed animus, in other words, Lindsay is adopting Trump's hatred of Letitia, it should not it's still, the claim fails. You shouldn't dismiss anything. She cites or quotes Trump's remarks about her, which span commentary, disdain, and deference. Trump says a bunch of things. When Trump was asked about the DOJ indicting her, he said, I look at the facts like everybody else. You read the facts, and to me, she looks terrible. Trump said she looks like she's very guilty, but that's going to be up to the DOJ. I'm not going to make a decision for them. Trump got asked a question. Are you going to punish your enemies? He said no, and not in any way, shape, or form. Did you instruct the Department of Justice to go after them? He says no, of course not. But if they find facts of criminality, that's their job to prosecute people. Now, Letitia makes much more of the involvement of Ed Martin, and we read Tish's original filing. She said Ed Martin was walking around in his Inspector Gadget trench coat outside her houses, and I thought Ed looked great. Martin is not the U.S. attorney. He didn't sign the indictment. He's not the decision maker in this process. Why is she obsessed with him? Defendant Tish, she maintains that Martin planned to use his authority to expose and to discredit opponents of Trump. But tellingly, Letitia describes Martin's perspective on charging decisions versus political activities. She even quotes him, saying, if they can be charged, then we'll charge them. Saying, we don't choose individuals to violate the law, okay? We choose people. They chose to violate the law, and when they violate the law, if we can prove it, we prosecute them. We're not making them break the law. We're not finding that they broke the law when they didn't. When they broke the law, if we find that they did, we charge them. So her remaining complaints involving Martin don't support any other dismissal bases. For example, she says that he communicated with Trump and took a photograph outside her residence. These are neither constitutional violations. They're not violations of the law at all. He's allowed to go do those things. Now, she also says that Martin sent a target letter to an elected official in the face of evidence giving rise to probable cause that she committed 2 crimes. In fact, it's not a vindictive letter. It's the opposite. It expressly discloses the government's perspective on how Letitia can timely accept responsibility for her crimes and demonstrate respect for the law, which is a routinely discussed point in plea negotiations and a factor courts must consider in sentencing. Happens with everybody else. She's not above the law. Everybody gets to have a conversation when they're being prosecuted and investigated. Sometimes you have to wait until you are, in fact, charged. But they were conversating with her before. For all of Letitia's talk about Ed Martin, there's no basis for why any of his actions should be imputed to Lindsay Halligan, who brought the case. Now, to succeed, they also have to meet a certain standard. It's called clear evidence of the animus. And they haven't done that here. Saying here, she is a statewide elected official. She's the biggest TISH in all of New York, whose conduct implicates multiple key priorities of the United States, federal government, public integrity, bank fraud, tax fraud, misrepresentations to financial institutions. The Eastern District of Virginia routinely prioritizes these cases, and we go after public integrity matters all the time. Even if the court finds that there is some genuine animus, she cannot establish that her charges were brought solely to penalize her. We charge people like this all the time. No clear evidence meets the standard. It's a high standard to show that we were discriminatory against her. If she wants to prevail on that claim, she's got to show a lot, and she hasn't done that here. Show by clear evidence that our decision to prosecute her was based on things like race, the decision to charge, race, religion, or the fact that she's exercising her rights. She needs to show that there was a discriminatory effect, and she hasn't done that. Lots of factors need to come into play here. Strength of the evidence and potential impacts. But the court doesn't even need to go to that level of analysis. She's pointing to other people who misrepresented stuff on their mortgages. She said maybe Ken Paxton did. Maybe Roger Wicker did. Letitia saying Scott Bessent did. She's identifying all these other people. Maybe they broke the law too. But these comparators rise and fall with her failure to even allege that jurisdiction exists over any of them except Roger Wicker. Now, the allegation against the remaining proposed comparator, Wicker, is a misrepresentation also to you, Judge. The Attorney General of the state of New York claims that a senator committed fraud based on an article that says literally the exact opposite. She cited a New York Times article, but the article says, quote, Mr. Wicker's office provided us, the Times, with a private loan document showing that he actually had attested that this was a second home investment property. So the article goes on to clearly detail that the reporting was mistaken, saying it was a clerical error, there was a misunderstanding, and Wicker is not implicated at all. So she's trying to say that she's being targeted and citing an article that shows that actually he's innocent. The priorities of the attorney all are in alignment with a very clear and straightforward prosecution. She is not being attacked, and this is not selective at all. Now, if she does want to make this claim, she needs to show that Lindsay Halligan brought this prosecution and these charges in bad faith. It means she needs to establish that she brought it on the base of her race or religion. They say those are not even implicated here. She was not charged with the crime for exercising her constitutional rights. She was charged for committing fraud. Now, she says in summary that Pulte came after her. Pulte coordinated with Martin. Trump and Martin spoke directly. Martin visited her home, and then they fired the good prosecutors and they put Lindsay Halligan in instead. But these arguments are easily explained and dismissed. In fact, first, Pulte's referral admittedly did not involve the Perone property at all. The facts that are the basis for probable cause for the commission of 2 federal crimes are not those which Pulte referred. In fact, while it remains to be seen whether those facts constitute Rule 404B evidence, like character evidence that you can bring in, the facts in this case are about Virginia. This simple, critical, in other words, they have nothing to do with these other properties, okay? This is about the Perone residence. There was a different property called the Sterling property and another property in New York. That's what the documents that Bill Pulte sent over for referrals were based on. This is a separate case and a separate prosecution. Now, second, even crediting news reports about Martin's communications, which are inappropriate to consider in the context of a motion to dismiss, Martin is not even a case agent or a line agent. He was previously appointed as an interim attorney in D.C. He has a leadership role in the administration. But the fact that he's working on this doesn't mean that there's some sort of discriminatory impact or discriminatory intent in the prosecution. It's not evidence of anything. Now, last, the employment decisions of who is the U.S. attorney has no bearing on any of this. Any internal recommendation for a different course of action is not a basis to dismiss a case. Prosecutors disagree all the time. Some say we should bring a case, some say not. And bad prosecutors are fired and good prosecutors come in and make a different decision. This means that even before a court allows a defendant to have discovery on this, they have to show more. They can't just go, fishing around for things. Her entire premise, Letitia's, for the motion here relies on news reports and social media posts that have nothing to do with Lindsay Halligan at all. She's made this argument, but it's unclear what she's actually saying. There is no basis to provide discovery at this point. She hasn't submitted enough evidence other than speculative news articles. And so, should this court find that this indictment was unconstitutionally vindictive or selective, the appropriate remedy would be a dismissal without prejudice. So we can indict her again. If it's with prejudice, case is gone. Can't come back. But because the dismissal of an indictment thwarts the public interest, a court may not dismiss an indictment with prejudice based on misconduct without first finding that they were prejudiced. Now, she says, I want it dismissed with prejudice. She says all federal prosecutors are prejudiced by President Trump. But this is way too harsh of a remedy. She needs to show how she suffered prejudice. But she instead wants to say that, in effect, she should be immunized. If the President Trump said anything bad about her, all the prosecutors are conflicted off. Everybody in the country cannot bring a federal prosecution against her because they'll all have imputed animosity and vindictiveness coming from President Trump down through whatever attorney is assigned to her. So she will be immunized forever if this was the standard, which is why I think that the DOJ has the better argument on this one. So unlikely, I would say, that this gets dismissed for vindictive or selective prosecution, but you never know with these judges. But a nice summary here showing what we've all known and long suspected, but it's nice to see it in writing. Not Selective or Vindictive at all. All these other people got prosecuted for this. And in 11 exhibits, we saw clearly TISH signing time and time again. This is a second home, not an investment property. She shoved her family in there after signing all of these things, after getting insurance and more. She then put her niece in there, claimed that she was losing money so that she could deduct it from her taxes, then told her accountant, oops, I shouldn't be doing that anymore because I'm going to be in trouble, after putting her family in there who came in, bought utilities, got them registered in their name, and then lived there. And when Letitia was actually even in town, she didn't stay at the residence. In fact, she stayed at the Renaissance Hotel, baby, and just lived it up on that sweet rental cash and that low mortgage rate extra moolah that she got. So she's busted, and the documents laid bare. Letitia James exposed. I'm under attack. No. Documents are coming in loud and clear. We can see them. You can see them. And now the judge can see them. So we're going to keep our eye on this one to see what comes next. But the judge will be issuing a decision. No doubt about it. Once it drops, we'll be here to cover it. Thank you for subscribing and joining as we do. All right, my friends. What a beautiful segment that was, huh? All right, now let's talk about some other things. We got some great stuff still coming up. We've got Jack Smith, Charlie Kirk, Tyler Robinson, and Kash Patel sued by a fired gay FBI agent. It's going to be nice. All right, so here is more. Jim Jordan, chairman of the Judiciary Committee, was spied on. We know that Jack Smith and his goons went after a bunch of people, senators and other House representatives, people like Ted Cruz, Lindsey Graham, Marsha Blackburn, Tommy Tuberville, Eric Schmidt, very powerful senators, and Jim Jordan. Now, what's even worse about Jim Jordan being spied on is this went on for years, apparently. Not just a couple days. We know Lindsey Graham was freaked out. He's like, who was I texting January 7th? I don't really remember. Years for Jim Jordan, gobbling up everything, who he was talking to, how long those conversations were, and more. He shared this. He says, they spied on President Trump. They spied on senators. Now we just learned they spied on me. If they can do it to us, they can do it to you. We said, well, we know they've been doing it to us for a long time. Under attack by our own government for years. But now Congress is getting involved. So Jim Jordan posted this. He says, look what we have here. Grand jury subpoena to Verizon Communications for any and all accounts associated with the following identifiers. Would have been Jim Jordan, phone number, address, email, whatever. Here's what we want. All records from January 1, 2020 to the present. We want subscriber information. They got all of this for Jim. He's going to explain it. Names, subscriber names, usernames, screen names, addresses, all call detail records, including but not limited to detail records for inbound and outbound calls, text messages, direct connect voicemail messages, length of service, start date, means and source of payment, all the identifiers, records of sessions, IP addresses, everything. So Verizon, give them to us and we will look at them. Here is another order that came down, filed under seal. Jim Jordan sharing this. This matter having come before the court, requesting an order to direct Verizon to hand all this crap over to our disgusting federal government. It is ordered that provider and its employees shall also not disclose the existence of the subpoena to any other persons except attorneys for Verizon for the purpose of receiving legal advice for 1 year. Once again, our executive branch spying on top Republicans. The scandal is so egregious. It literally makes Watergate look like a joke. Okay. They went in, broke in and took some physical files or, whatever they made up, whatever the CIA did. This is years of data gobbled up by Jack Smith and his goons. And here is more from the story. So the Oversight Committee and Judiciary Committee now going to have to answer and figure out what went down here. But the Biden Justice Department, as we're learning, subpoenaed Jim Jordan's personal phone records back in 2022, seeking more than 2 years of data, all related to Arctic frost, which ultimately led to charges against the president. So Fox News, Ashley Oliver, they say this subpoena was drafted and gobbled up in 2022. The full subpoena Fox News got shows a federal prosecutor who later worked on Jack Smith's team ordered them to give them all the data all the way back to January 1, 2020, 2 years. The request appears to be the most expansive yet of these known subpoenas. And I got to imagine it's just massive. There's probably a lot more involved here. And this begs the question, are they going to go after Stacey Plaskett's text messages for interfacing with Jeffrey Epstein? Maybe we should go and subpoena all of the records from her, if this is what we're doing now. Just saying. But all the way back to January 1, 2020? To see if he was plotting for January 6? Yeah, Smith did not begin working on the case as special counsel until they handed him all the files, until 7 months after the subpoena was issued. Now, the subpoena for the records appears to be one of the first known of the Arctic frost probe. And the toll records did not include the contents of his phone calls or the messages, but it did include details about when and where, with whom, and more. It also sought records for 3 other phone numbers and included a 1-year gag order that was signed off on by the judge. And so we got the full set of documents right here. Let's take a look at them. From James Burnett to Verizon Legal Process and Compliance. Please find attached. I'm J. Brian Burnett here, J. Brian. I'm a senior special agent at the DOJ. Hey, Verizon, please find attached a grand jury subpoena and a non-disclosure order for service May 1, 2022. And where is he with? Office of the Inspector General. That's curious. So before Jack Smith came on board, of course, we read this. The judge who signed off on this is a magistrate judge called David Baker. And here's more. All right, Verizon. Pursuant to a criminal investigation, we demand that you give us information. If you choose to send this via FedEx, let us know. Under the Electronic Communications Act, we're allowed to ask for these things, and we are doing that now. Signed by these prosecutors, Timothy Dury, and we should know if he's still there, if he is still there. With a little bit of investigation, I think this is a good indicator he should be fired. Kenneth Polite, probably him too. Don't know if he's there or not, but if you're going to be executing and demanding search warrants and phone records of your political opponents, not a good marker for your future employment. So Verizon, you are commanded to give us Jim Jordan's phone records. Courts, of course, all sign off on it like it ain't nothing. Timothy A. Dury, he goes and makes that request. Grand jury subpoena. And the rest of it's pretty form stuff. We want all the text data. Send it. All image data. It's insane. Jim Jordan's records for 2 years gobbled up by hack FBI prosecutors and Office of Inspector General prosecutors, saying here, everything, give it to us immediately. Absolutely crazy. And then they don't even know about it. Executive branch spying on our congresspeople. And in this case, the chairman of the Judiciary Committee. So he was on with Sean Hannity. And here's what Jim had to say about some of this when it came up.
Contacts were in the information they got. I want a lawsuit.
Yeah, well, Sean, we say this all the time, but I mean, the only thing we get wrong when we start these investigations is it's always worse than we thought. So think about this. We know they spied on President Trump. Then we learn it's senators and the Speaker of the House. And now we learned they were spying on me for 2.5 years. I mean, think about 2.5, all the way back, as you said, to January of 2020. They gathered information that told them who I called, who called me, when we called each other, when the call took place, how long the call was, and where I was at when I made that call. They got your location as well, and they gathered that for over a time period of 28 months. This is how ridiculous this is and why we are doing everything to get to the bottom. You're right. I bet there's a bunch of other members of Congress, a bunch of other citizens like you all over this country that they were looking into, because this is the epitome of the weaponization of government against against the other party. President Trump, Republican, all the senators, the Speaker of the House, Republican, and of course the top Republican on the Judiciary Committee. That's how ridiculous this whole thing is.
Did they get your text? Because I've had thousands of my personal private text messages released to the public.
Great question.
They didn't get it from me. They never got it from me.
J6 committee.
I don't save text messages. I don't have an iCloud, but they end up putting it on, putting it up there in hearings and in the newspapers and use it in criminal.
Yeah, the J6 committee acted like little investigators and sent congressional subpoenas over to everybody, including Sean, and said, give us everything you had. What'd you have for lunch yesterday? I want receipts for this. It was insane. And the courts allowed it to happen. There was a total dragnet that went by, which is why we get so irritated with Congress. Like, what are you guys doing? They gave everybody who was a political opponent an enema, essentially, as soon as they took power. 1,500 J6ers plus or minus, got arrested, right? And by this time, when the Democrats were in charge, we had hundreds of arrests already. And Congress was already forming committees. They had Hollywood producers coming in. And I guess they're just, now our Congress is just like, well, we want to let you know this is happening. We're going to let you know it's happening. And then when they put in a $500,000 penalty, which is like, I guess the best they can come up with, then they fight about it amongst themselves.
Cases of which I am not a party to. Yep. Now, do I deserve some degree of privacy? Do you deserve that?
Yes, you do, Sean.
I think you do.
Yes, you
It's
do.
called the Bill of Rights. It's called the Fourth Amendment, for goodness sake. Of course you do. Our understanding of this subpoena is they got the time you sent the text, who you sent the text to, just like they would with the call. They did not get the contents of the text. But we know the January 6th committee got some context of text from you and from me and everyone else. So, but this subpoena was for when those texts were sent, not the actual contents of it. But what I want to know is who signed off on this ultimately? Did Chris Wray know about this? This is the Biden DOJ. Did Merrick Garland know about this? Because this subpoena was...
They all knew about it.
Sent in April of 2022. Did Lisa Monaco, the Deputy Attorney General?
Yes.
Who signed off on this? This idea that you got one branch of government run by Democrats going after the...
Haul them all in. Send them all subpoenas and demand that they answer questions about it. And if they don't abide by the subpoenas, then you can hold them in contempt and charge them.
Legislative branch at the time run by Republicans. I mean, the top Republicans. That's how crazy this all is. So, look, we're going to keep gathering information. We're going to be ready for when we bring Jack Smith in for his deposition, because we're going to have a lot of questions for him.
They determined that, quote, disclosure would result in a flight, that you might flee the country, or that you might intimidate witnesses. Who made that determination? Because that is the exact opposite of the person I know.
The same people who said we're going to take Scott Perry's phone. The same people who said we're going to surveil a member of Congress, Scott Perry, for a week. Go find out where he works. Find out what kind of vehicle.